Good afternoon. I am Pratyush Kumar from National Law University, Delhi. Today I shall be speaking on the module Originality Requirement in Copyright Law. Originality requirement in copyright law shall cover issues of its meaning, its nature, what are the requirements which would determine originality, what are the different tests determining originality, what is the quality of work irrelevant, what are derivative works, what is the sweat of brow doctrine, what is creative standard doctrine, what are FIEST publications, and what is the position in our country, India, and I shall conclude thereafter. To begin with, introduction. The term copyright can be literally construed to mean something as simple as the right to copy. Before the invention of the printing press in the 15th century, the need for a law protecting the copying of books or manuscripts did not arise because of the arduousness involved in manually copying a book. But soon, with the invention of printing, the need for a law prohibiting unauthorized printing, sale, or import of a book arose. And in England, a series of law, ordinances, bylaws, acts, etc., were passed to cater to this need. The Licensing Act 1662 is the first statute that expressly mentions inter alia that the ownership of a book or copy thereof by the owner to be a common law right. This finds a clearer interpretation in Lord Justice Mansfield's words in Miller versus Taylor, where he says, "Because it is just that an author should reap the pecuniary profits of his own ingenuity and labor, it is just that another should not use his name without his consent. It is fit that he should judge when to publish or whether he will ever publish." So the key words essential here are ingenuity and labor. How important are these words to the establishment of copyright over a copyrightable work will be seen in the following paragraphs. What is the meaning of originality? Isaac Newton once wrote, "If I have seen further, it is by standing on ye shoulders of giants." True to the very spirit of the statement, there is no work, literary, musical, or artistic, which can be said to be completely novel or unknown to mankind. The ingenuity of an author lies in his expression of his own ideas. In other words, the way in which an author chooses to arrange the known forms of expression, words, musical notes, objects, et al., is unique for each author, and that uniqueness is what we call originality. The first hurdle that a work has to cross to be copyrightable is the test of originality. To comment on the appropriateness of this test, one has to go back to the common law approach to copyright. The key words, as were earlier pointed out, were labor and ingenuity. According to Lockean theory of property, the rationale behind providing an author with copyright over his/her work lies in the labor that the author puts in making the work in its present form. Another important theory of intellectual property worth mentioning here is the personhood theory. This theory states that when a person works on anything, he expresses his personality on that subject. So, as humans in themselves are in possession of their person, so by extension they should also be the owners of subjects or objects they have worked on, as they become extension of their personality. But there are other schools of thoughts that maintain that mere labor in producing a work is not enough for making it copyrightable. The other key word comes into play: ingenuity. Ingenuity is essential because of two reasons. A. According to the incentive theory of intellectual property rights, including copyright, is an incentive for intellectual work carried on by the author of a given work to make a certain work. Copying a certain work cannot be the intellectual work envisaged by the theory. B. Doing away with ingenuity to promote copying or plagiarism or piracy, giving rise to free riding, again devaluing a product of real intellectual work, and as the object of intellectual property law is to promote the progress of science and useful arts, copying and free riding goes against the very spirit of intellectual property law. The next natural question that crops up is how to determine originality in a work. We will try to answer this in the next section, which is different tests for determining originality. Now, the tests for finding out originality have evolved through various case laws. We will look at a few case laws that have helped find the various tests used for determining originality in a copyrighted work. Quality of a work irrelevant. Though the importance of originality in copyright protection was earlier acknowledged in many cases, the first case where the issue of originality was expressly dealt with was Blestein versus Donaldson Lithographing Company. In this case, the opinion of the court was delivered by Mr. Justice Holmes. He laid down the law very clearly that the copy is the personal reaction of an individual upon nature. Personality always contains something unique. It expresses its singularity even in handwriting, and a very modest grade of art has in it something irreducible, which is one man's alone. That something he may copyright unless there is a restriction in the words of the act. So, the quality of a work or the merit of a work does not determine its copyrightability. What does is whether the work is the author's own or plagiarized from somewhere. But the issue is not as simple as it seems. What are derivative works, which is the bigger issue for copyright? Now, the issue with originality looms mostly over derivative works, which are works which are derived from other works. For example, compilation of facts, directories, law reports, etc. The complication seems to arise from the settled position of law that no author may copyright his ideas or the facts he narrates. So, the natural question which arises is, how can a compilation of facts be copyrightable? Various courts have addressed this concern of monopolization of facts in various case laws, and on careful analysis of them, two schools of thoughts or tests seem to have evolved over time in dealing with originality in derivative works, which are: first is the sweat of the brow doctrine. The sweat of the brow can be thought to be the traditional approach to copyright protection. This test recognizes the labor put in by an author or compiler into the making of a work. So, according to this doctrine, irrespective of any creativity or judgment on the part of the author, if it can be proved that the author has expended considerable labor and expenses over the making of his work, he is liable to get his work protected by copyright. Mere industrious gathering of data and facts, even when such effort lacks imagination or judgment, entitles the compiler to get a copyright. Lord Halsbury's judgment in the landmark case of Walter versus Lane can be said to be the paradigmatic sweat of the brow doctrine. In this case, several public speeches were reported in the Times newspaper at various occasions. Later, the defendant published a book containing all these speeches and short notes on them. It was also admitted by the defendants that these speeches were taken from the reports in the Times. The Times sued for copyright infringement of the speeches they published. Lord Halsbury laid down that there is considerable labor involved in reproducing spoken words into writing or print and first publishing it as a book. And so, if a telephone directory can be protected by copyright, so can a verbatim report of public speeches. The sweat of the brow doctrine can hence be thought to be one which does not distinguish between an author and a publisher. In other words, under this doctrine, a publisher is equally entitled to the copyright in a work as an author. So the difference between a work and a product is completely blurred under this doctrine. Hence, this doctrine also seems to stress on the fact that the purpose of copyright law is less protection of authorship and more stopping misappropriation by others of any labor. The other doctrine that has evolved with time and through various case laws is the doctrine of creative standard. It maintains that a work must be creative to be original and thus protected by copyright. A major landmark case that glorified this doctrine in the US is Financial Information Incorporation versus Moody's Investors Service. The case involved daily issues of 4 inches into 6 inches index cards printed with information concerning current municipal bonds being called for redemption. Typically, the information consisted of the identity of the issuing authority, the series of bonds being redeemed, the date and price of the redemption, and the name of the trustee or paying agent to whom the bond should be presented for payment. According to the plaintiff, they had expended considerable effort and money to compile the information. The Second Circuit, on appeal, while rejecting the copyrightability on the bond cards and remanding it back, affirmed that a compilation may receive a valid copyright only if something has been added to the data, the authorship of the compiler in making the requisite selection, coordination, or arrangement of the data. In England, again, Lord Robertson's dissenting judgment in the landmark case of Walter versus Lane can be said to be the paradigmatic creative judgment. Lord Robertson, in his dissent, highlights the nature of reporting a speech verbatim, which is reporting it as it is. On this premise, he further states that a copyright cannot subsist in such a verbatim reporting of a speech because there is no scope of any construction on the part of the maker. He distinguishes it from the telephone directory cases on which Lord Halsbury had relied on saying that those are at a different plane than this. Hence, the creative doctrine requires the maker to do something more than pure industrious compilation, be it giving structure or organization, or the compilation must display originality in the selection, creativity and judgment in choosing the compiled materials. Hence, the creative standard doctrine seems to affirm a view of copyright as concerned with the recognition of authorial dignity, unlike the sweat of the brow doctrine. After this, the Feast publications case became a solution once and for all. In Feast Publications versus Rural Telephone Service Company, a similar situation involving the copyrightability of a directory listing the names, towns and telephone numbers of a large number of people of a certain area arose. On the question of copyrightability of compilations, the Supreme Court of United States emphatically laid down the following dictums. First, author is he to whom anything owes its origin. Originator, maker. 2. Facts do not owe their origin to an act of authorship. The first person to find and report a particular fact has not created the fact. He or she has merely discovered its existence. 3. The choices undertaken by the compiler as to selection and arrangement, so long as they are made independently by him or her and entail a minimal degree of creativity, are copyrightable. However, the court spelt out a limitation to this copyrightability. Copyright protection may extend only to those components of a work that are original to the author. So, if for instance the selection and arrangement are original, only these elements will be copyrightable. The facts themselves do not become original, howsoever original the format and arrangement might be. 4. Originality is not a stringent standard. It does not require that facts be presented in an innovative or surprising way. It is equally true, however, that the selection and arrangement of facts cannot be so mechanical or routine as to require no creativity whatsoever. The standard of originality is low, but it does exist. The last point, the sweat of the brow doctrine is rejected by the copyright statute as it requires selection, coordination and arrangement of facts in such a way that it as a whole constitutes an original work of authorship. Based on this test, the court came to the conclusion that the impugned directory was copyrightable because of its originality in alphabetically arranging the same. Hence, a clear position was reached by the American Supreme Court, wherein they found a middle way between these two extreme schools of thought. So now a dictionary, for instance, is copyrightable merely by virtue of its original arrangement, if it has one. But how far has India adopted or shunned these tests in determining originality? For the position in India, one of the most landmark cases is R.G. Anand versus Deluxe Films and others. It's a 1978 Supreme Court decision. The court held, where the same idea is being developed in a different manner, similarities are bound to occur. In such a case, the courts should determine whether or not the similarities are on fundamental or substantial aspects of the mode of expression adopted in the copyrighted work. If the defendant's work is nothing but a literal imitation of the copyrighted work, with some variations here and there, it would amount to violation of the copyright. In order to be actionable, the copy must be a substantial and material one. The court also went on to say that one of the surest and the safest tests to determine whether or not there has been a violation of copyright is to see if the reader, spectator or the viewer, after having read or seen both the works, is clearly of the opinion and gets an unmistakable impression that the subsequent work appears to be a copy of the original. Now, in another case, another landmark decision, it is a 2008 Supreme Court decision, Eastern Book Company and others versus D.B. Modak and another, where the touchstone of law relied on by the court was, first point, section 5214Q excludes the reproduction or publication of any judgment or order of a court, tribunal or other judicial authority from copyright unless the court, tribunal or any other judicial authority makes it copyrightable. Second point, the Copyright Act is not concerned with the originality or literary merit. Third point, a copyrightable derivative work should be original in the sense that by virtue of selection, coordination or arrangement of pre-existing data contained in the original work, the new derivative work is somewhat different in character. Fourth, to secure a copyright in the judgments delivered by the court, it is not sufficient to show that the author has produced the material with merely labor and capital. Fifth, derivative work produced by the author must have some distinguishable features and adds flavor to raw text of the judgments delivered by the court. Now, I would like to conclude. So, originality is important in understanding copyrightability of a work in question, and the tests for determining originality have evolved over time to form the present standard of test as laid down in Fiest Publications or CCH Canadian Limited or Eastern Book Company case. The stance of the courts in most jurisdictions seem to be quite liberal. They acknowledge copyright of a minimal amount of originality if a minimal amount of originality is shown, which happens in most of the cases, but they rightly filter out the minuscule amount of cases where even the minimal amount of creativity is missing. The present regime bars such mechanical copying work from entering the copyright regime. The importance of originality and its present position in the copyright regime point towards the encouragement and promotion of intellectual property, one originating anew from the human intellect, and discouragement of free riding on someone else's intellectual property. Thank you.